Good afternoon, everybody, and welcome to this joint webinar between Trafalgar House and Gowling on how to change pension administrators, the practical and legal considerations. Just before we start today's session, I'll cover off some pieces of housekeeping. Today's session will last approximately 45 minutes, with the presentation taking around half an hour. We've then left some time at the end to take your questions. As you would expect, the session is being recorded, but the cameras and microphones of everyone attending the session are turned off and muted throughout. A copy of the slides we're using today, the recording and the transcript will be made available to everyone after the session ends. If you have any questions, then please do raise them with us. We really want to hear from you. To ask questions, please use the Q&A function at the bottom of the screen. In order to not interrupt today's presentation and to keep the time, we'll answer the questions at the end. But if we don't get to your questions in the session, then we would encourage you to contact us directly. We'd be happy to answer any follow-up points you might have that we don't have time to cover on today's session. So let's get today's webinar started with some introductions. My name's Dan Taylor. I'm Client Director at Trafalgar House Pensions Administration. My role is to oversee all of our client relationships, which always start with the transition of new clients into our operation. I've worked in pensions administration for over 20 years and have been involved in setting up and running third-party administration businesses, as well as working on well over 100 administration transitions. Most recently, I've acted as project sponsor on a transition where Gowling were the appointed scheme lawyers. And it was on this project that all parties found the negotiation and appointment process painless and successful. So we thought it would be a really good basis and opportunity to share some of our tips and experience on how to manage these processes. My co-host for today is Maddie Frost, who I'll hand over to introduce herself.
Thanks, Dan. Good afternoon, and thank you for joining us. I'm Maddie Frost. I'm a legal director in the pensions team at Gowling's. I advise on all aspects of pensions law, mainly advising trustees of occupational pension schemes. And in recent years, I've advised on a number of trustee clients in respect of changing their administrator from both in-house administration to third-party administration, and from third-party to a new third-party administrator. Now, as Dana said, the plan for today is for us to just give you a feel for both the key legal issues that arise when transitioning from one administrator to another, and for Dan to talk about some of the practical issues. And as we've recently worked together on a transition that went very smoothly, we thought it's a good idea to not only share our thoughts on why we think it went well, but also what can sometimes go wrong. So the agenda for today. So aside from leaving a bit of time for questions at the end, there are 6 key areas that we're going to cover today. The first is preparing for the transition. This is arguably the most important part of the process. Get this part right, and often the rest will fall into place. Then we're going to talk about exit negotiations and agreements. Now, this is the divorce, so to speak, from the incumbent administrator. And it could be a relatively simple process if exit terms are clearly set out in the current agreement. But if that's not the case, we can talk about some of the key provisions you want to get in your exit agreement. Then we'll touch on best practice for new administration agreements, and I will highlight some of the key front-end legal provisions, and Dan will look at some of the issues relating to service schedules and expected service levels. We'll then mention data protection considerations. I'm sure you appreciate it's outside the scope of today's session to look in any detail at data protection. It could be a session in itself, and I'm not a data protection specialist, but I will highlight the things that you need to think about and when to seek advice. And then we will mention benefit specifications, how important they are, common issues uncovered with them. And as we go through, we will look at some key risks, pitfalls, and their solutions. So to start with, I'm going to pass back to Dan, who will look at the first stages of preparation.
Thanks, Maddie. As we've said, changing pension administrators is complex and can be a daunting task. But as you can imagine, the topic and requirements are extremely broad, and we don't have enough time to talk you through everything. So we're just going to highlight the key challenges. So as Maddie says, we're going to start by looking at how best to prepare for a transition. And the first thing that I really want to look at is the planning phase. And within that planning phase, the first thing that anybody who's participating in these projects needs to decide is who is going to participate, who are going to be the right people to really invest in the process to make it a success. So the first part of an effective plan should always start with looking at who is going to participate. And key to making sure there is no disconnect between each part of the program. And you need to really make sure that you tie in a project group that can stick with one of these programs over many weeks and months. They tend to be very long processes, so make sure everyone is preparing for the commitment. In fact, last week I completed a transition that took a full year from the first approach to the final project closure meeting, and this full year timescale is pretty typical. So planning on who is going to participate needs not only to encompass representation from each of the key stakeholders, typically trustee, company and members, but you may also need to consider any functional specialists who can support the process, especially in much more specialist and detailed areas such as systems, communications and commercial discussions. Most reviews now include deep dives into areas like cybersecurity and business resilience, as well as third-party supplier management. So if you have people who can support you in these specialist areas, either from the trustee board or from the company, then I highly recommend you get them involved from the start of the project. On the next slide, there are some examples of typical project roles that should provide a good basis to start considering who you might want to slot into each position. We're not going to cover those in detail today, but we've supplied them as a piece of reference information. One big question I'm always asked is, when should I undertake the process, or is there an ideal time to get it underway? And it's a very common question for trustees and pensions managers to ask. And when it comes to annual timetabling, then the simple answer is no, there probably isn't a best time, as there will always be tasks that are in flight over the course of a year or perhaps even a longer period. However, I would encourage anybody embarking on one of these programs to think about the more macro events or larger strategic changes that a scheme might be going through. Significant rule changes or benefit changes, large fund switches or scheme closures are not ideal times to be changing administrator. Also, please consider times that will demand lots of time from the trustee board as well, such as around valuations. Those are times or events that are best to be avoided. But I really wouldn't be too concerned about the timing of annual events, as most of these can be accommodated through the implementation plan. Some people recommend to aim towards the live date of a new administrator at the start of a new tax year, but that often has its own challenges as well, as lots of events kind of get focused around that time. So my tip here is don't be too concerned about the micro, but do think about the larger things that schemes or trustees have on their agenda, where it wouldn't be a great time to be embarking on one of these programs. When you've got your team together and you've started to identify some of those more specialist type roles, as well as who will fit into the structure that we've given you for a governance structure, you then need to think about what your selection criteria might be. And when it comes to criteria, and when I engage with trustees, I always ask them, what sort of administration service do you want? And I always pretty universally get the same answer. We just want a better one. And it's a view and opinion that I have great sympathy with, but it's not one that's particularly helpful when you're kind of entering this process, or from the supplier side, actually, when you're talking to trustees about what type of service that they want. I understand the motivation, but it's really important to build a more detailed picture of what the future requirements and priorities are. And it's really important through the selection process, as well as the ongoing relationship. And I'll explain why a bit later when we start to look at how you construct your administration agreement. The one thing I would say here is that not all administrators offer the same solution. Getting familiar with what's available in the market is often the best starting point. So if you really don't know what type of service you're looking for, then go out into the market and start having conversations with administrators now. You don't have to enter a full formal review process to understand what different offerings might be. Most administrators are happy to have a non-committal introductory session where you can get to know a little more about them, see some of their materials and systems, and that should help you form a picture of what's really important to you. Areas of focus and consideration, though, are the split between core and non-core functions, i.e. how much importance is the delivery of change projects you have compared to things like the member service. I think JMP equalisation and de-risking has brought that into relief a lot more for trustees. What's your appetite for the introduction of web or digital self-service solution? What's most important to you and your members in terms of the service proposition? What member service priorities do you have? And a big tip here is to look back on recent experience. What are the issues that you and your members have encountered, and what are you trying to resolve? But don't be seduced by a service option if it's not relevant to you. We administrators get very excited and motivated about the latest bit of technology or innovation that comes onto the market. And if you start having engagement and conversations with administrators, that's probably the thing that you'll see first. But be cautious about seeing the bright new shiny toy. It may not be something that's absolutely essential to your service. So make sure you have a good definition of what your criteria might be. And then selection. So the final point here, the final thing to think about on your preparation is you need to think about which administrators you want on your list. There is a lot of constraint in the market at the minute. So don't be surprised that some administrators may not be interested in your service. And from the supplier side, there's lots of things that you look for. The first thing might be whether the client has a bundled service. The size, the complexity, the timing of a scheme may also come into play, whether you consider whether it's a right option for you as well. The market is very congested at the moment, and so that's why an expression of interest is a really useful tool. And often what you'll see now is that trustees or pension managers will put together a proposal on a page, a single one-page summary of what the scope of services and the scheme structure might look like. And you should encourage administrators from the market to send you a single page summary on a page to come back that shows that tells you whether they're interested in your contract, what their scope of services or recommended structure might be, and what timescales might be involved. It's a really good, quick, easy way to get a measure of the market and where the right home for your scheme might be. One tip here is that you will probably need to wait longer than you anticipated, because lots of administrators are being much more selective and cautious about implementation timescales. So be prepared for your timescales to shift a little when you get through that process. I'm going to hand over to Maddie, and she's going to talk you through the other 3 items.
Okay, thanks, Dan. I suppose preparation from a legal perspective then. I mean, I think from the beginning, the trustee should be mindful that it is legally responsible for the administration of the pension scheme, and it's the trustee's decision who to appoint as its scheme administrator. Now, effective administration is absolutely critical to the proper operation of the scheme and the delivery of intended benefits to members. So it really should be part of the trustee's risk management for the scheme. Now, of course, the pensions regulator is very keen to ensure that schemes are properly administered and expects the trustee to pay close attention to the operation of the administration function. This is evident in the regulator's new single code of practice, which is intended to bring together previous codes, and it sets out expectations that the trustee has to that the TPR has on trustees to maintain and monitor good scheme administration. It's also evidenced actually TPR's interest by its recent defined benefits survey that was published last month. The primary objectives of that survey was to provide TPR with a greater understanding of schemes and their administration practices and strategies. So against that background, the trustee should carefully consider who it wants to appoint as its administrator. And sometimes trustees will appoint a third-party evaluator to assist in this process. This is a professional who can help focus the trustee's mind on what is important to it in the tender process, to identify candidates that would be a good fit, to help assess a shortlist against some pre-established criteria, and to develop a project plan and to ensure that parties stick to it. But whether or not the trustee has the aid of an evaluator, it should first take a step back, consider and agree, and I would recommend document what key factors are important to them and what their expectations are. And Dan has already talked about the criteria that the trustee should consider, and just to note that e-administration capabilities should be at the forefront. It's particularly encouraged by the recent PASA guidance on the journey to full e-administration. So what other process support might the trustee need in the process? Well, it may want to establish a working group to progress the appointment and transfer. It can be quite a time-consuming process. So a working group with regular reporting back to the trustee can be valuable. The trustee is going to need legal advice, particularly on the terms of the exit agreement and the front end of the new administration contract. Advice will also be needed around other contractual arrangements and how to exit them as a result of the transmission. And of course, the support of the new administration plus the cooperation of the outgoing administrator are essential to aid a smooth transition. A really important factor to consider when preparing for transition is giving notice to the outgoing administrator. So you need to check the termination provisions in the current agreement. Now, many administration agreements will be set for an initial term, so 3 or 5 years, where it's not actually possible to terminate for choice in that period. And once that initial term has passed, either party is usually able to terminate by giving a prescribed period of notice to the other party. So firstly, check whether you're in the initial term, and if so, can you even terminate? If you can terminate, there may be consequences of doing so, for example, being liable to pay certain fees. Even if you're beyond the initial term, check what notice has to be given to terminate. Generally, it's a long notice period, anything from 60 days to a year, and check what formalities are needed to give notice. For example, who should the notice be given to, and who should the notice be given from? And if it's in writing, can this be done by email? The trustee may want to consider having a discussion with the outgoing administrator before putting in the formal notice to start that early and good dialogue about the transition. However, factored into when you give notice would of course be how long that notice period is, and the trustee doesn't want to be in a position where the outgoing administrator is no longer obliged to provide the services, but the new administrator is not actually ready to go live. And this is where the handover terms will be key. It's also worth noting what other key contracts the trustee has in place for its own arrangements, such as software or contractual arrangements with member tracing services. It's important at an early stage to determine if these services will still be needed following the transition, and to build in time to exit such arrangements if necessary. And the trustee should also think about the service that may not strictly fall under the remit of pensions administration. So I'm thinking about secretarial services, and decide who's going to do this following the transition. It may be for schemes that were previously had in-house administration, that these are kept in-house, but it's equally possible that these services will be transferred from an administrator, and it may be that a separate agreement is needed for those ancillary services. So it's important to bottom out all these different parts of administration and make sure you're on the same page as your new administrator about what will be included in the services and what will not be included in the services. Dan, I think I'm going to pass back to you now to look at data sources and timelines.
Thanks, Maddie. Yeah, so within the next couple of slides, we've just set out some of the, as I said earlier, the project roles that you might want to give some early consideration to, and where people would slot into these various different roles. On the next slide, we've also given you an idea of where various data sources for an admin transition might come from. I'd also encourage anybody who's considering this process to look at some of those sources as well, because if you can find data and documentation and information from other sources than the outgoing administrator, then that can often speed up your implementation transition as well. And very often there's very good high quality in-house teams who can act and supply certainly governing documentation for an implementation, which can both, as I said, increase the time, the time span, and often increase the support for the project as well. So giving some early thought to where the source of these data items might be will really help in your preparation. But one of the big questions that I don't want to spend too much time on today, because we are focusing on the admin and legal consideration, is the timescales, the overall timescales for admin transitions. The other reason why I don't want to spend too much time on it as well is because people can kind of hold me to account on this point, which is very difficult to do because there are so many variables when it comes to administration transitions. The complexity of schemes, the sophistication of requirements, the new administrator's existing commitments, the outgoing administrator's capacity to hand off a scheme, which often isn't thought of or considered as part of the planning process. But I have given some outlines of our experience at Trafalgar House on where we're seeing typical timescales over the last few years taking place for admin transitions. As you'll see, the first part is around the selection process. So this is from the very first approach to the point where an administrator is given preferred supplier status. We typically see that taking around 1 to 3 months. Contracts and appointments, this process is becoming a little bit more extended. We've seen that extend over time simply because now cybersecurity, information security, data hosting, and third-party supplier management are becoming much more focused areas within contracts, rightly so, requiring a lot more specialist inquiry, often as well sign off from the sponsor as well. So we're seeing those processes extend the contract negotiation to around 1 or 2 months. But one of the, I think, most surprising parts for a lot of trustees is outgoing exit terms and negotiation. We're seeing these processes take between 2 to 3 months. And yeah, very often we see that as one of the key areas that delays the overall migration process. Transition timescales can then take anything beyond a year, and it's really as vague as that. If you're looking at a large scale administration transition that includes the transfer of people under 2P, then you could be looking up to anything up to about 1.5 years. But to put a fixed timescale on that is very, very difficult. So please use this as kind of a yardstick for your estimates for your own programs. Minimum contract terms for administration agreements are now somewhere between 3 to 5 years as well. So I'm giving you this as kind of, as I said, a yardstick, but it's very difficult to fix on the timescales. But if you're using the kind of outer numbers, then you should be in a pretty strong position. Once you get to the end of your selection and appointment process, the next thing then is what does the next phase of the look like? What does the transition process look like? And Rosie, if we can go into the next slide, then what I've done here is set out the 4 stages that we follow at Trafalgar House, which is broadly within these 4 kind of buckets of work. And the first one, where actually most of the work and effort and time goes in, is the learn phase. We're going to look at this a bit more detail when we come to look at the benefits specification and best practice and process to be followed under that. But the learn stage really is the part of the transition where your new administrator gets up to speed on how the scheme operates, what systems and processes need to be put in place, and the kind of more practical documentation that goes behind administering a scheme. Also, the governance structures, reporting, and project management goes into the learn phase, but it's easily the part of the process that consumes most resources. Phase 2 is deployment, so where an administrator puts in place their systems, builds calculations, and puts in place processes and comms. That tends to be the part of the process where you hear least from your new administrator because they're working in-house to develop all of the materials they use. And then thirdly, and I think from a client and a trustee perspective, the test phase is the part of the process where you should expect to see and hear most from your administrator. It's where they're testing their systems, checking back all the learning that they've put in place, and comparing it to past practice. It's where you'll see things like data quality testing coming through, and also the results of past case review. Finally, I should expect there's a final go live stage where all of the groundwork is put in place and the service can go live. The one thing that I would stress both through the timelines as well as through the transition process as much as you can, is to consider that when you are forecasting an implementation, very often you're being asked to do it a year or 18 months in advance. And any project, especially one as complex as this, it's virtually impossible to get that go live date exactly right. So give yourself options. Sometimes delays or issues can be uncovered through the process, which means that the only viable option is to change the live date. And whilst all parties will want to avoid this, and it can sometimes be the harder option, it can also be the least risky as well. So be flexible and plan for the unexpected. And that comes through both your exit negotiations and exit agreements, as well as the agreement with your new administrator as well. With the best will in the world, it's very, very difficult to forecast everything within these programs. So make sure you have as many options as you possibly can and build in extension periods with your outgoing administrator. And then the final thing that I'm going to point out again is that exit negotiations consistently cause most delays in the project. And getting that exit agreement in place and the first set of deliverables, we see commonly causes most delays throughout the transition process. There are options that you can deploy. It's sometimes better to get an initial cut of data under a change control, but please focus on how you will leave as much as how you will start, and that will make sure that any forecasted plans have a better chance of success. And when we come to look at the divorce, the first step in this process is really establishing what the requirements are. And it's really up to your new administrator to take the first kind of shot at defining that. While your outgoing administrator should have and will probably have a list of deliverables within their agreement, it's unlikely to have the kind of granular level of detail that will need to be stipulated by your receiving administrator. So what you should expect to happen is your new administrator should supply you with a detailed document that will set out exactly what is needed and when. Once you have this, you can then supply it to your outgoing administrator, who'll put together their fully detailed exit plan and costs associated with the plan as well. But as I said, even though you might have exit provisions in your agreement, it won't necessarily state all of the detail and all of the deliverables that will be required. Be prepared for some negotiation through this process, and please just focus on the most important thing, which is making sure everybody's delivering the highest quality transition as well. If the negotiations aren't going to plan and there's an extension, be prepared to revise your overall timescales for the programme. And Maddie's going to cover off some legal tips and advice on the best way to approach this.
Thanks, Dan. So I think you can hear that we're advocating an exit agreement should be included in the administration agreement. But if that's not the case and it's not there, or as Dan said, even if it is there, it probably needs some refining and detail added to it. So it's not too late. The trustee will just have to agree one. Now, PASA has a voluntary code of conduct on administration provider transfers. Now, the purpose of the voluntary code is to set out a framework which will aid the transfer of services between providers, to give some clarity in respect of the responsibilities and accountabilities, and to limit the potential for delays. And this helps to focus minds on protecting the interests of members. It's not just a matter of exiting from a commercial contract. The people that will be affected by delays or ineffective services will be the beneficiaries of the scheme. So it's important to get this process right. So what contractual exit terms will we advise? Well, generally, we will have a commitment that the administrator will, of course, continue to provide the services as required under the current agreement, except to the extent that it's transitioned to the new administrator, and also to provide services that the trustee reasonably requires to facilitate an orderly transfer. Now, the exit agreement will usually state when the administrator will stop providing services, but as Dan said, we would always recommend some flexibility in there, because sometimes things don't go to plan and it's necessary to extend that period of time with the outgoing administrator. We think it should have a detailed transition plan in any exit plan. And an important part of the agreement is the obligation on the administrator to provide data to the new administrator, and we suggest that the agreement sets out a list of what data the trustee expects to be provided, when and in what form. We'd recommend a commitment on the administrator to assist with knowledge transfer. That means it will acknowledge that it may be asked to explain documents and material to the new provider. And finally, the exit agreements should set out the costs and how these will be charged as part of the process. So that's the exit agreement. And now I'm going to pass back to Dan, who is just going to start off the discussion about the new administration agreement.
Thanks, Maddie. I'm just going to make one point. Now, when you're starting to form your administration agreement, there is actually a really useful document that goes into a lot of detail, more detail than we can cover on today's session. It's the Key Principles of Administration Agreements, published by the PMI in November 2014. It's still a really relevant and useful document, and it certainly gives some excellent advice and guidance when you come to look at your attaching service schedules. So if anybody wants to read more about this, then that's a really useful reference document. I'm going to hand back to Maddie. She's going to just pick up on some more of the detail of the new agreements.
Okay, so before we get stuck into the content of the new agreement, in my experience, it's helpful to set out how this process is going to work. Ordinarily, the administrator provides the first draft of the agreement, and discussions always start on a better footing if this first draft reflects discussions between the parties to date. For example, if certain commitments were given or agreed as part of the tender process, they should be included in the first draft of the contract. To get a generic contract with no tailoring, it's a bit of a frustrating place to start. I also think being mindful of who negotiates the document helps. Now, clearly both sides will have lawyers drafting and amending the clauses. However, it's important that the lawyers know what their respective clients' priorities are. And I find negotiations go better when it's not left lawyer to lawyer, but you have a client relationship manager from the administrator, pensions manager or chair of trustees on behalf of the trustee, and they steer the process. And from a trustee's perspective, they often like to see the relationship manager being someone who they met at the tender stages and who they obviously warmed to because they were successful in that process. So for the trustee to see that continuity of personnel is a really good start to building a strong relationship. And also we've said this, set a realistic deadline for getting the agreement in place. It's a really important contract. They have detailed schedules, so allowing time to get this document in place is a good idea. So in terms of some key clauses, the services, it's really important the agreement clearly sets out in detail the services to be provided under it, and time should be spent on the description of services and associated fees. There should be a robust standard of care expected from professional third-party administrators and a commitment that they will comply with industry standards, coupled with a commitment to ensure that their processes are up to date and fit for purpose and will continue to be. Also that the administrator will commit appropriate resources to the provision of services. Then liability cap, it's usual for the administrator to restrict its financial liability to the trustee under the agreement. The liability accepted will generally reflect the size and complexity of the pension scheme and the services to be provided. Now, although advisors can provide some guidance on what an appropriate liability cap may look like, this is ultimately a commercial decision. The final provision I was going to mention is the delegation. The administrator will usually want the ability to delegate certain functions to third parties, and the trustee will be asked to agree to this delegation of certain parties listed in the agreement. The trustee needs to be happy with this list, but the way it normally gets happy with the list is by the administrator confirming contractually that it has taken due care in the selection of these delegates, and it remains responsible for their actions. And of course, the other provision under the agreement that's important from a legal perspective is the termination provision, but I've already spoken about that. And although no one wants to talk about the divorce on the wedding day, it's important to get those termination provisions right. Dan, I think I'm passing back to you to talk about services.
Yes, please, Maddie. I just want a quick word on really about the attaching schedules within a service agreement. Kind of past the negotiation, the service schedules are the kind of most live important part of the agreement for an administrator and for trustees and clients as well. And one really important factor within there is service measurement. And I would encourage everybody to make sure that their service agreements have a heady mix of qualitative and quantitative service measures in there. The quantitative ones are always the easiest ones and probably the ones that all administrators will put in there from day one. They're the ones I think that people assume they have a more kind of objectivity around them rather than qualitative ones, which can sometimes be argued to be more subjective, but they needn't be. There are lots of good measures available that your administrator will always already be tracking. So they should be included in them. And examples are things like member feedback, error rates, automation rates, personnel changes, and the results of independent audits and any exceptions that are highlighted from them. And those qualitative measures can actually have a really powerful effect of driving the right behaviours with your administrator only after you've set the key service criteria. One other factor that is now commonplace in agreements is the use of service credits and debits or bonuses. They're now very commonplace in agreement. They're used to give a commercial incentive to achieving goals and business aims and or penalties for underperformance. My tips here are that they should be used to remedy persistent issues rather than kind of things that will naturally crop up over a service environment. And be careful with any debits not to fundamentally undermine the commercial nature of the contract. They can kind of lead to a death spiral where your administrator does not have the resources and investment to remedy the issues that are causing the service credits. And if this happens, then you're in a kind of nightmare scenario where the administrator can't invest anymore, can't remedy the service because the commercial nature of the agreement is fundamentally damaged. But certainly start with that mix of qualitative measures, and there should be a good mix of them in there as well as the quantitative. And yeah, they can be objective as well. They don't all have to be subjective measures. So please make sure you're focusing and including some of those in your agreements as well. And on the list there is a typical list of schedules, and this has kind of grown over the past few years, and we're getting more and more schedules added. I think data protection has been one of the key areas that's grown and expanded over recent years. But this list of 14 schedules are some of the most common ones you'll expect or should expect to see in your agreement. I think Maddie wants to pull out just a few of them that are particularly important from a legal perspective.
Yeah, so the schedules, as you can see, they can be quite numerous, but the ones that we tend to look at are the key person schedule. Now, there may be key people that are really important to the trustee in the provision of services, and if the trustee does identify particular personnel or roles that will be key to it, these can be listed in a schedule, and then with requirements to inform the trustee or to sometimes seek the trustee's approval before those people or roles are changed. Another important schedule is the change control schedule. This is a procedure whereby the trustee or the administrator can request a change to the services. It's usually referenced in the main body of the agreement with the detail in the schedule, and we suggest that this sets out the process for making a change to the services. We recommend it includes a template, timescale for considering change requests or coming up with an alternative. It should have a broad approach of how the parties will agree to additional fees, which individuals can request and approve a change. And we would also always recommend that the change request forms and their approval should then be appended to the administration agreement and kept together as an audit trail of what the amended services are. We've already talked about the handover schedule in a bit of detail, and we recommend that that's included. But the final schedule I'm going to talk about in a bit more detail is the data protection schedule. The data protection considerations, as Dan said, have become more numerous over the past years, particularly since the introduction of the GDPR, which is still applicable despite Brexit. It's applicable under UK law. I noted at the outset I'm not a data protection lawyer. I have excellent data protection lawyers here at Gowling's who I will get to look at the data protection provisions. But the agreement will need to ensure that there's a legally binding contract in place between the administrator and the trustee, setting out a number of clauses that are required by GDPR. And we also always think that it assists with this handover if the trustee actually goes back and makes a list or revisits the list that it did at the time GDPR first came into force. So look at its information flow mapping to see where the information needs to go, from whom and by when. And it's also really important that the trustee updates its privacy notice following this process. I'm conscious of time, but I just do want to make a note about cybersecurity. There should be robust cybersecurity provisions in the administration agreement. The pensions regulator has cybersecurity firmly on its radar, and the damage caused by cyber attacks has been widely reported in the press. So we would recommend that the administration agreement refers to compliance with cybersecurity policies, sets out how the administrator ensures its team are aware of issues relating to cybersecurity, and it should also set out what happens if there is a data breach or a cyber incident, with a steps plan of what needs to be done by whom and when. And on the topic of cybersecurity, the trustee and the administrator should both be aware of both the pensions regulator's guidance on cybersecurity and the PLSA's guidance on cybersecurity. Now I'm going to pass back to Dan, who is going to look briefly at knowledge capture.
Thanks, Maddie. So yes, just one area I think it's really important for us to highlight is the knowledge capture process and the creation of the benefit specification. The administration market tends to talk an awful lot about data, but you don't hear so much about rules and administrators' adherence to them, strangely. But this is where we at Trafalgar House commonly see the most complex and costly issues arising, especially when administrators change. And it's the creation of the benefit specification that covers most issues and skeletons. In fact, I think there's a very good argument to state that you can't really look at data until you have a very good quality benefit specification in place. So what is it? It's the central reference document administrators use to calculate and pay benefits. It's the working practical document that translates the rules into very functional outputs, formulas, workflows, and decision trees. And whilst people like Maddie spend a lot of time looking at rules, we spend a lot of time looking at benefit specifications. The process itself involves administrators, mainly people in technical teams working through deeds and announcements to construct worked examples of rules and how benefits are calculated. Often this is done from a first principles basis, which means that the only reference that's made for these documents is back to the original rules. Once it's created, then the specification is then tested in practice against historic results and historic cases. And then once all that's in place and everyone's satisfied that it's the best representation of the scheme rules, it's then used as the basis to automate calculations. It's the most important due diligence step an administrator takes when accepting a DB client, or in fact, actually a DC client. It covers both types of entities. And the process can very often uncover differences in the treatment of benefits, interpretation, and this is where really a good, strong relationship between administrator, actuary, and lawyer becomes very, very valuable through the process. I would stress that it's such a useful tool that it needs to be updated and reviewed annually, and trustees need to make sure there's provisions in their agreement to make sure that it's reviewed, and that so the specification doesn't lose relevance over time. And most critically as well, that specification forms part of the trustees' intellectual property. You will want it if you change administrators again in the future, and you'll want access and use to it as well. So as I said, it's one document where an awful lot of time and effort goes into it. It's a really important basis. So make sure it's reviewed and make sure you still have access to it if you ever change administrators in the future. And I think on the next slide, there is just a few of the most common issues that are uncovered when a benefit specification is drafted.
So I'm going to mention one thing on the benefit specification before we go to our takeaways, and that is, I think it's important that all parties acknowledge that the benefit specification is a really important document, that appropriate due diligence needs to be done on it. However, there must be an understanding that it's not the role of the new administrator to actively find problems. And discrepancies will be found. I mean, there will be issues, but it shouldn't start from the premise that this is automatically an error by the past administrator or a misinterpretation by the new administrator. It's often issues that come to light may initially seem like an error, but actually it's a different but still reasonable interpretation of the scheme rules. So I think if everyone has that in the back of their minds when they're looking at the benefit specifications, then it can help with progress. So my legal takeaways, I'm conscious of time. First of all, expectations. The trustees should discuss and agree the key factors it wants from its new administrator and write them down. It's important not to lose sight of that as you go through the detail of the administration contract. The contract itself, if the administrator can provide this to the trustee for review, tailored, all the better. It aids for productive negotiations. Other providers always check if a change of provider will have a knock-on effect for other third-party service providers. And an ongoing dialogue. This is the beginning of a relationship. So make sure communication channels are open and issues can be aired and resolved quickly and efficiently. So Dan, your key takeaways.
Thanks, Maddie. Yes, so like Maddie, I've got 4. I think the first 3 speak for themselves. Don't rush the process. The second one, in terms of roles, make sure you have the right people in place and give some forethought to specialisms that you might need, and you might need to rely on through the selection process, and keeping the same people through the process right through selection into the implementation process and beyond. Think about the exit, make sure that's not going to unduly delay and to derail the process. But then finally, I think a really important point, and a point that Maddie made earlier, is don't rely on your lawyer to negotiate absolutely everything for you. You must engage with the process because there are some really important decisions to be made, commercial decisions and operational decisions that in fact your lawyer's just not going to be able to do on your behalf. And you do really need to engage with the process and make sure that anything you've defined through the criteria really does follow through into your service agreement, because the reality is you will be managing those schedules and your administrator will be delivering against them for a very long time, 3 to 5 years. So making sure that they're right and they reflect all of your key strategic aims is really important. I did say at the beginning, Maddie said as well, that we had an awful lot to cover today. So I think we were a little bit ambitious trying to do this in half an hour, given the range and scale of matters. I've been keeping an eye on the Q&A box. I think we've got a few minutes now where we could take a question if anything, if anybody has anything they'd like to raise. If we don't, then Maddie and my contact details are available. So we're happy to take questions and speak to you after the session if you want to know anything more about what we've covered today. Just another final point, as I said, a copy of the slides, the transcript and the recording will be available. It's probably going to be a few days before we publish it as well, so please be patient for us. With us, I don't think there's anything coming through on the Q&As, and I think as we've run up and a little way beyond our time, we'll probably leave things there today. So it just leaves me to say thank you for your time. Hope it's been useful, and I hope you've got some useful tips to take away and consider before you start your administration transition process.
Thank you.
Thank you.